A sitting federal judge writing a published appellate opinion stopped mid-analysis and reached for two words nobody expects to find in a legal document: James Bond. Not sophisticated, not well-engineered, James Bond-like compartments. That was how the Seventh Circuit Court of Appeals described what investigators found when they finally cracked open Mario Lloyd's distribution vehicles. And here is the thing about federal judges. They don't do that. They reach for precision, they reach for precedent, they reach for statute numbers. They don't reach for spy franchises. So when one does, you sit up and pay attention, because it means whatever they're looking at genuinely startled them. It means the cars were so well built, so completely impossible to find unless you already knew what you were looking for, that the most formal legal writing system in the country had to borrow from Hollywood just to explain it to the reader. That one phrase tells you more about what Mario Lloyd built in Chicago than anything else in the record. He wasn't running a corner operation. He was running something that looked from the outside like a legitimate business, and from the inside like a corporation with a board of directors, a compensation structure, a distribution network, and a logistics arm sophisticated enough to make a sitting appellate judge think of James Bond. Mario Lloyd went to trial in 1989 with F. Lee Bailey, one of the most famous criminal defense attorneys in American history, standing next to him. He lost. The jury convicted him on every single count. The judge sentenced him to 15 life terms. He appealed for decades. He lost every appeal. Then a woman from Chicago with no private jet and no celebrity co-signer filed a clemency petition on his behalf and worked for free until the president, in the last 72 hours of his administration, signed his name and let a 60-year-old grandfather go home. This is the full story of Mario Lloyd. To understand what Mario Lloyd built, you first have to understand the specific economic and social landscape he was operating in. Chicago, in the late 1970s and through the 1980s, was a city undergoing profound structural transformation. The manufacturing base that had employed working-class South and West Side residents for generations was collapsing as plants moved or closed, leaving concentrated unemployment in neighborhoods that had no comparable replacement economy. Into that vacuum, the cocaine trade arrived with the kind of timing that, had the product been legal, would have been studied in business schools as an example of perfect market entry. The cocaine economy of that era was not simply a series of unconnected street-level transactions. In cities with sophisticated criminal infrastructure, it developed into something that, at its upper levels, required genuine organizational skill, reliable supply chains, disciplined distribution networks, financial management capable of absorbing and concealing enormous cash flows, and the kind of insulation between senior decision makers and street-level operations that protects the organization when individual members get caught. Most people who attempted to build operations at this scale made the same predictable mistakes. Too much personal exposure, too little insulation between the top and the bottom, too much cash left unaddressed in ways that drew attention before the organization was ready to weather it. Mario Lloyd, according to the federal record, did not make most of those mistakes. He studied the landscape, identified its vulnerabilities, and built his operation specifically around closing them one by one. He sourced product directly from Colombian suppliers, bypassing the middlemen that most distributors in his position relied on. He ran distribution through both Chicago and Milwaukee, a corridor of roughly 90 miles along Interstate 94, giving the operation geographic breadth that made individual arrests far less destructive to the whole. And he solved the problem that destroys most sophisticated drug operations far before law enforcement closes in. The problem of what to do with tens of millions of dollars in cash that cannot be simply deposited, declared, or spent without attracting immediate federal attention. The federal court record describes the result as a captained operation, a specific word choice that implies hierarchy, direction, and deliberate leadership rather than the more loosely affiliated structures that characterize most drug organizations at the street level. Mario was at the top of that hierarchy, directing it, and the distance he placed between himself and the street level activity below him was not accidental. It was the product of careful, sustained organizational thinking by someone who had studied how these operations tend to fail and had built his accordingly. Mario didn't hire accountants. He didn't hire financial advisors. He hired his mother. He hired his sister. He hired his brother. Blood in, blood in, blood in. His mother, Connie Walker. His sister, Antoinette Lloyd. His brother, Charles Lloyd. All of them on the payroll. All of them performing specific documented functions within the enterprise that individually might have looked like ordinary family activities and, taken together as a federal indictment laid them out, constituted a comprehensive money laundering operation embedded within a blood relationship. Charles served as one of the primary distributors. He received large quantities of product and was responsible for moving it through his own established network with workers beneath him who answered to him rather than directly to Mario. That layer of human distance is critical. If one of Charles's workers got caught and cooperated, they could testify about Charles. Getting from Charles to Mario required additional steps. This is how sophisticated criminal enterprises survive, not through secrecy alone, but through deliberate structural insulation. There were other layers below Charles as well. The federal record names, distributors, and workers further down the chain, each compensated for their role, each aware of only their specific part of the larger operation. The man unloading product at the bottom of the chain knew Charles, or knew the person Charles sent. He did not necessarily know Mario, could not point to Mario in a courtroom from personal knowledge, and that distance was not an accident. It was the architecture of the thing, built exactly the way a successful organization builds its resistance to disruption, by ensuring that no single point of failure can compromise the whole. Connie Walker and Antoinette Lloyd handled a different dimension of the operation, converting the proceeds from cocaine distribution into legitimate-looking assets. The mechanism was real estate. The Seventh Circuit's appellate opinion in this case documents the purchase of townhouses, condominiums, expensive cars, furs, and jewelry, a portfolio of legally acquired assets purchased with money the government characterized as proceeds of cocaine distribution. The logic is straightforward. Cash sitting in a box is evidence. Cash converted into real property registered under names with apparent legitimate income is far more difficult to trace and seize. The first lesson Mario reportedly learned about this process came early. He walked into a real estate closing and placed cash on the table in a grocery sack. The bank flagged it, informed him they were required to report the transaction to the IRS, and that was the end of that particular approach. He adapted, spreading transactions across multiple institutions in amounts deliberately kept below the federal reporting threshold, a federal crime in its own right known as structuring, and one that left a trail of paper that prosecutors would eventually find extremely useful. What he couldn't move through real estate, he stored. Federal search warrants executed during the investigation recovered approximately $1.25 million in cash spread across 3 separate bank log boxes. Not a savings account, not a financial instrument, not an investment, physical cash sitting in boxes, waiting. And while all of this was happening, while the condominiums were being purchased and the lockboxes were filling with cash, members of Mario's family were simultaneously collecting government assistance benefits, receiving public aid at the same addresses where luxury goods purchased with drug money were being delivered. None of them, except Charles, who reported a small business loss to the IRS, filed tax returns. Charles's own tax filing showed a loss on what he described as an automobile business. The man who was distributing cocaine for a multi-million-dollar enterprise told the federal government he had lost money selling cars. Federal prosecutors did not find this persuasive. The James Bond-like compartments referenced in the appellate opinion deserve their own examination because they represent something genuinely unusual about how Mario Lloyd approached the logistics of his operation. The baseline problem for any large-scale cocaine distribution network is physical. How do you move hundreds of kilograms of product through a city and across a 90-mile interstate corridor without exposing the product to discovery during routine traffic stops or targeted surveillance? The standard approaches, hiding product in luggage, concealing it within legitimate commercial shipping using human couriers, all have documented failure rates. Law enforcement has seen them all before and knows exactly where to look. What Mario's operation apparently did instead was invest in custom fabricated concealment systems built directly into the vehicles themselves. The federal record does not provide a specific engineering description of what these compartments looked like or how they were constructed, but the appellate court's choice of the James Bond analogy is informative. In the Bond franchise, the vehicles are remarkable not for being fast or powerful, which anyone can achieve, but for being effectively impossible to comprehend as anything other than what they appear to be without specific knowledge of what to look for. A car that is, to all external inspection, simply a car, but that contains mechanisms, spaces, and systems invisible to anyone not already aware of their existence. That is what the Seventh Circuit was describing, not a compartment under a seat. Something purpose-built, engineered, and expensive enough to produce that the most senior levels of the federal appellate system reached for a film franchise to explain it. The investment required to build vehicles like that is considerable. You need access to skilled fabricators who understand both automotive engineering and the specific requirements of concealment, people who can modify a vehicle's structural components in ways that survive a physical search by trained law enforcement. You need people who can keep that knowledge entirely to themselves. You need a supply chain for the components and a workshop capable of handling the modifications without attracting attention. The cost of all of that is not trivial, and the ongoing operational complexity of maintaining a fleet of modified vehicles, repairing them, replacing them when they become known to law enforcement represents a sustained organizational effort most drug enterprises never invest in. The decision to make that investment represents a specific philosophical commitment to long-term operation over short-term profit. You don't build James Bond cars if you're planning to run for 6 months and disappear. You build them if you intend to run for years and expect to be searched repeatedly without being found. Mario Lloyd's operation ran long enough to generate between $20 and $30 million in documented revenue. Those cars were part of how it lasted that long. For all the sophistication of the operation's physical infrastructure, the paper trail it left behind became the foundation of the federal case against it. Every real estate transaction generated documentation. Every structured bank deposit generated records. Every conversation between Mario and his distributors and workers generated potential testimony from people who, when eventually faced with the alternative of long federal sentences for their own involvement, made the entirely rational decision to cooperate with prosecutors rather than remain silent. This is the fundamental vulnerability of any criminal enterprise that achieves sufficient scale. The larger you grow, the more people know enough to be valuable to a federal prosecutor, and the more people face the kind of sentencing exposure that makes cooperation a genuinely attractive option, regardless of whatever loyalty commitments were made when times were good. Key among those who ultimately cooperated was a man named Troy Shelton. Shelton had, at different points, worked for Mario, for Charles, and for another distributor named Ronald Jackson. At trial, he provided detailed testimony about cocaine distribution across the operation, testimony that prosecutors described as direct, specific, and damaging to multiple defendants simultaneously. Then came the twist. After the trial concluded, Shelton found himself housed in the same jail cell as Ronald Jackson, one of the men against whom he had just testified. From inside that cell, he produced a handwritten letter. The letter claimed, in direct terms, that everything he had testified to under oath about Ronald Jackson was false, and that the government had pressured him into providing the testimony. Jackson used the letter to seek a new trial. Mario attempted to join that motion, despite the fact that Shelton's letter did not mention Mario by name even once. Every court that reviewed the recantation concluded it did not warrant a new trial. Courts evaluating witness recantations look at whether the recantation is credible, whether the original testimony was material to the conviction, and whether a jury would likely have reached a different result had the recantation been available. The courts in this case found the circumstances of the recantation, specifically that it was produced while Shelton was physically housed with one of the defendants he had testified against, and that it conspicuously omitted any reference to the Kingpin at the center of the operation to undercut its credibility substantially. Whatever actually happened in that jail cell, the recantation letter as produced was not enough to move any court to act on it. Mario Lloyd did not walk into the federal courthouse with a public defender. He arrived with Francis Lee Bailey, and it's worth being precise about what that meant in 1989, because the name carries implications that are easy to underestimate from 3.5 decades later. By 1989, Bailey was already a legal legend. He had represented Sam Shepard in the case that inspired The Fugitive. He had defended Patty Hearst, the media heiress turned bank robber, in one of the most publicized criminal trials of the 1970s. He was one of the most recognizable and most expensive criminal defense attorneys in the United States, a man whose courtroom reputation was built on the kind of methodical, aggressive cross-examination that had dismantled prosecution cases considered airtight before he arrived. A second attorney, Kenneth Fishman, served as co-counsel. This was not a defense assembled by a person who lacked resources or who underestimated the severity of what he was facing. Mario knew what he was up against, and he hired the best available response he could find. Think about what that decision communicates. You don't hire F. Lee Bailey if you're hoping to quietly negotiate a plea deal and serve a few years. You hire him when you intend to fight, when you believe the case can be won at trial, when you are willing to go all the way in front of a jury rather than accept whatever the government is offering. Mario made that bet. He put the full weight of one of the most celebrated legal minds in American history behind his defense, and he put it behind a decision to go to trial rather than cooperate. It was not enough. After a 6-week trial, the jury convicted Mario Lloyd on every single count in the indictment. Every one. The breadth of the conviction reflected both the strength of the evidence and the scope of the charges, which covered not just the cocaine distribution itself, but the money laundering infrastructure, the structuring violations, the conspiracy, the full architecture of the enterprise the government had spent years documenting. The postscript to Bailey's involvement in this case carries its own particular irony. The attorney Mario, paid to keep him out of prison, eventually spent time in federal prison himself. In 1996, while representing a client in a separate case, Bailey was held in contempt for failing to account for millions of dollars belonging to a convicted drug smuggler that he had transferred into his personal accounts. He served time behind bars. His law license was subsequently stripped in Florida and Massachusetts. The most famous defense attorney in American history, the man Mario brought into his federal courtroom to fight the United States government, did not live to see the outcome of Mario's case, dying in 2021, having spent his final years disbarred and in financial distress. After a lengthy trial and conviction on all counts, the district court moved to sentencing. The central charge driving Mario's ultimate sentence was a single count under a specific provision of federal law, engaging in a continuing criminal enterprise. This provision, sometimes referred to in legal shorthand as the Kingpin statute, was designed specifically to address organized drug enterprises rather than individual transactions. Under the law as it stood at the time of Mario's sentencing, a conviction on a continuing criminal enterprise count carried a mandatory life sentence with no possibility of parole. The sentencing judge imposed life on that single count, then added 14 additional counts on top of it, producing the headline figure of 15 life terms. The judge also imposed a fine, $26 million. For a man who had just been convicted and who would spend the rest of his natural life in federal custody under the existing law, a $26 million financial penalty was largely symbolic, but it reflected the scale of the operation as the court had assessed it. Mario appealed and kept appealing and kept appealing. He filed motions arguing sentencing errors in calculating the drug quantities attributable to him, and ineffective assistance of counsel at various stages of the proceedings. He represented himself through substantial portions of the post-conviction litigation, a significant undertaking given the complexity of federal habeas and appellate practice. He was not by any measure a passive participant in his own legal fate. He fought for decades through every channel available to him. One collateral review did partially succeed. A court determined that, as a technical matter of the statute as applied to the specific counts, the correct number of life sentences under the law should have been 5 rather than 15, and resentenced him accordingly. The Seventh Circuit, reviewing that resentencing, noted in its written opinion with a dryness that could charitably be described as judicial understatement that the reduction made no practical difference to Mario's situation, and that Mario, the court noted, does not profess concern about whether additional life sentences would affect him following reincarnation. A sitting federal judge included a reincarnation joke in a published legal opinion about a man serving multiple life terms. The gap between the law's formal language and the reality of a human being living inside that sentence had produced something close to dark institutional humor. Meanwhile, the disparity in outcomes between Mario and his co-defendants had its own story to tell. His sister Antoinette, convicted alongside him on money laundering, conspiracy, and structuring charges, received a sentence of 45 months, under 4 years. Mario received 5 life sentences, later reduced from 15, not because Antoinette's conduct was minimally connected to the enterprise, but because the law in that era, operating through mandatory minimums tied to specific charges and drug quantities, produced outcomes that reflected the hierarchy of the indictment rather than any nuanced assessment of individual moral culpability. Mario was the top of that hierarchy and received the sentence the law prescribed at the top. Consider what 36 years of incarceration actually contains. Mario Lloyd entered federal prison in 1989. In the time he spent inside, the internet was invented, commercialized, and restructured the entire global economy. The Cold War ended, the Berlin Wall fell, the September 11th attacks happened. The first black president of the United States served 2 terms. Social media rose from nothing to dominate human communication. Multiple wars were fought and ended. Every one of these things happened in a world Mario was physically removed from, watching only through the narrow window available to someone serving life in a federal facility. Children were born, grew up, had children of their own. Funerals happened that he could not attend. Birthdays accumulated unacknowledged by his presence. The architecture of a family rebuilt itself over 3.5 decades around an absence at its center, working around the space where Mario was supposed to be. His own clemency petition noted with understated significance that Mario had no prior convictions before the 1989 case, no prior criminal record. A first-time offender was sentenced to life in federal prison for a cocaine distribution enterprise, and the law at the time gave the sentencing judge effectively no room to reach a different result, regardless of what any individual jurist might have concluded about proportionality or rehabilitation or the appropriate human response to a first offense, however serious that offense was. There is something specific about the phrase first-time offender that is worth sitting with. In this context, it does not mean innocent, it does not mean the conduct was not serious or that the harm caused by the enterprise was minimal. It means that prior to the 1989 indictment, Mario Lloyd had no criminal record, which in most areas of sentencing law serves as a significant mitigating factor, reflecting a recognition that a first offense, even a grave one, suggests a different calculus about likelihood of recidivism and the purposes of incarceration than the record of someone who has been convicted repeatedly. The mandatory minimums of the late 1980s largely overrode that calculus, requiring specific sentences that left judges little discretion to apply that kind of individualized reasoning. What a sentencing judge might personally have concluded about proportionality was, in many of these cases, legally irrelevant. The law prescribed the outcome, and the outcome was life. Here is the part of Mario Lloyd's story that most directly explains why it took 36 years to resolve what the law itself had come to view as an excessive outcome. The sentencing era that produced Mario's result was characterized by mandatory minimums that removed judicial discretion in exactly these kinds of cases. Congress, responding to public alarm over the crack cocaine epidemic in particular, had built sentencing frameworks that required specific sentences for specific quantities without regard to the individual circumstances of a given defendant. The result was a wave of sentences that, viewed from a distance of 2 or 3 decades, even Congress itself acknowledged had been excessive and in many cases racially disparate in their application. In 2010, the Fair Sentencing Act took direct aim at one of the most documented disparities in the existing framework. In 2018, the First Step Act went further, making some of those reforms retroactive and allowing people already serving sentences under the old framework to petition for reduction. The federal prison population saw thousands of people receive reduced sentences through those mechanisms. Mario fell through the gap. His case involved powder cocaine rather than crack, which meant the specific disparity reforms that unlocked reduced sentences for many others did not automatically apply to him. Every major legislative reform that swept through the sentencing framework during the years he was incarcerated reached him and then turned out to be half an inch too short. His attorneys filed motions under each new provision as it became law. Each one came back, not quite. What was left, after every legislative channel had been explored and found insufficient, was executive clemency. The president's power to commute a sentence is not a judicial finding. It does not require a showing of legal error. It requires a decision by the executive that the ongoing incarceration of a specific individual no longer serves a legitimate governmental purpose proportionate to the human cost of continued imprisonment. While Mario was working through his appeals from inside a cell, a Chicago attorney named Angel Cody was building what she described as the decarceration law firm, a practice focused specifically on representing people serving life sentences for drug offenses and doing so entirely for free. By the time Mario's case reached her, she had already walked more than 40 people out of federal prison. 40 individuals who had been told in formal legal terms that they would spend the rest of their natural lives incarcerated. She had gotten them home. The clemency process in the United States is not a judicial procedure. It doesn't require showing legal error. It doesn't move through courts or apply established legal standards to facts. It is, in its essence, a political and humanitarian act, a determination by the executive that the ongoing incarceration of a specific person no longer serves a legitimate governmental purpose proportionate to the human cost of keeping them confined. That means the strength of a clemency petition lies not in legal argument alone, but in the construction of a complete human picture, documentation of who this person is, what they have done with the years they have served, who is waiting for them, and why continued incarceration serves no purpose that a just society would recognize as worthwhile. Cody filed a clemency petition on Mario's behalf that made exactly that case. She documented his decades of incarceration, his lack of prior criminal history, his age, his family, his conduct during his time inside. A Change.org petition supporting his release gathered thousands of signatures from members of the public who had never met him, people moved not necessarily by Mario Lloyd the person, but by the category of outcome his sentence represented. A first-time offender, serving life under laws his own government had spent 30 years walking back. Letters were written, donations made to legal funds supporting the effort, and the case was built from multiple directions simultaneously toward a single desk in the White House. On January 17, 2025, 3 days before the end of his term, President Joe Biden signed commutations for nearly 2,500 people convicted of nonviolent drug offenses who were serving sentences that Congress itself had acknowledged were excessive. The list included people who had been inside for decades, waiting for exactly this kind of executive action to reach far enough down into the sentencing structure to touch them. Mario Lloyd's name was on that list. It required 36 years of incarceration. It required a family that did not stop fighting. It required a petition gathering thousands of signatures from strangers. It required a lawyer working for free. And it required one signature delivered 72 hours before that option expired entirely. That is how close the margin was. Hold two images in mind simultaneously, because together they say something the rest of this story can only gesture at. Image 1, 1989. Mario Lloyd walks into a federal courthouse with F. Lee Bailey at his side, one of the most celebrated criminal defense lawyers in American history, a man who would later stand next to O.J. Simpson in what became known as the trial of the century, the best available defense money could purchase. He lost anyway. Image 2, 2025. A black woman from Chicago, no private jet, no celebrity co-signer, no legal legend, files a clemency petition on behalf of a 60-year-old grandfather she represents for free. She won. Francis Lee Bailey died in 2021, disbarred, stripped of his licenses in 2 states, financially ruined by the very conduct that eventually ended his career. He never lived to see the outcome of the case he lost in Mario Lloyd's courtroom. Me Angel Cody is still working, still filing petitions, still getting people home. In the summer of 2025, Mario Lloyd walked out of federal prison. He was received by his children, his grandchildren, his nieces and nephews, a family that had spent 36 years at a door the law had told them would never open. The doors that had turned him away through 36 years of appellate motions and legislative reforms that stopped just short of reaching him had been unlocked not by the legal dream team he hired in 1989, but by a woman working for free who simply refused to stop filing until the right desk in the right building received the right petition at the right moment. That is an uncomfortable thing to sit with, regardless of how you feel about Mario Lloyd specifically. The difference between walking out and dying inside was not ultimately determined by guilt or innocence, or even by the quality of the legal arguments made on his behalf. It was determined by who was still filing paperwork and whether a president with 72 hours left in his term decided to sign his name. Is that justice? It is a genuinely difficult question to answer cleanly. Mario Lloyd built a cocaine distribution enterprise with revenues of $20 to $30 million that moved hundreds of kilograms of product through Chicago and Milwaukee, employed his own family in its financial operations, and generated the kind of human damage that any large-scale cocaine distribution network inevitably produces in the communities it supplies. He was not, by any reasonable reading of the public record, a sympathetic figure in the conventional sense of that word. He built something sophisticated and profitable and deliberately insulated from accountability, and he ran it for years. He also received from a legal system operating under rules that Congress itself subsequently acknowledged were excessive and racially disparate in their application. A sentence of 15 life terms for a first offense, a sentence that kept him inside a federal facility for 36 years, beyond the point at which the law that produced it had been substantially rewritten. The sentence lasted long after the logic that generated it had been repudiated. That is not a small observation. There is a version of this story where both of those things are simply allowed to coexist without resolution, because the honest answer is that they do coexist in the actual documented record. Mario Lloyd caused harm. Mario Lloyd received a sentence that the legal system itself came to regard as disproportionate. These facts do not cancel each other out. They both just sit there in the appellate opinions and the clemency petition and the congressional record, requiring no reconciliation because the legal and political system was never asked to reconcile them. It was only ever asked eventually to do something about one of them, and it took 36 years to get around to it. The machinery that produced Mario's outcome in 1989 was not aberrant. It was the law operating exactly as designed in exactly the era for which it was designed. The question of whether it produced proportionate results is one that the legal system itself spent the subsequent 3 decades slowly and imperfectly trying to answer. Mario Lloyd's release was one small part of that answer, delivered 36 years late, 3 days before the administration that delivered it left office. The James Bond cars, the lock boxes, the grocery sack full of cash at the real estate closing, the letter written in a shared jail cell, the reincarnation joke in the appellate opinion, all of it sits in the public record permanently. What it adds up to depends on which part of the story you're standing in and when.